We start with a new phase now in the trial of Kyle Rittenhouse. The defense is now calling witnesses after prosecutors rested their case yesterday.
One of the last pieces of evidence from the state was never before seen drone video. It shows the moment Kyle Rittenhouse shot Joseph Rosenbaum. Medical examiner testified it was unclear whether Rosenbaum was lunging for Rittenhouse's gun at the time or falling because he'd been shot.
Bullet goes in and across and down.
That's correct.
Okay, so once again, in the position of lunging would put you in a horizontal position, correct?
It would.
But they would be, as he's in a horizontal position, perhaps falling after being struck in the hip.
That's right.
The judge dropped a charge against Rittenhouse for violating city curfew. He still faces the more serious charges. Felonies, the most serious of them, comes with a potential life sentence.
And the defense will call more witnesses to the stand starting this morning.
So we're joined once again by our local defense attorney and legal analyst, Patrick Cafferty. So Patrick, the defense widely expected to call Kyle Rittenhouse to the stand, but his attorneys are already building their case of self-defense with other witnesses. Who are these early witnesses and what are they being called to add to the conversation?
Good morning. So generally speaking, my observation of the defense at this point is they're attempting to create doubt about the case that the government or the state has created, because keep in mind, in a criminal case, the state has to prove beyond a reasonable doubt that the person did what they did, and whatever defense they're claiming is applicable is not applicable. They have to basically prove a negative. So in calling certain witnesses, the defense is attempting to undermine the credibility of the state's case as a whole. So for example, the defense called Nathan DeGroon, who indicated that the prosecutor had attempted to get him to change his testimony. I don't know whether that's true or not, but one way or the other, if the jury believes that's true, it's going to undermine the credibility of the prosecutor once he gets up there during closing argument. They're going to have doubts about what it is he's saying. The other thing that the defense has done by getting the curfew ticket dismissed is, again, undermining the government's case. The government's position has basically been he didn't belong there because he was out after curfew. He didn't belong there because nobody had invited him to protect this car lot. He didn't belong there with a gun because he was underage. The defense has now undermined those theories that the state is attempting to put forward. They've put forth witnesses who say, yes, he was welcome at the car lot. He was legitimately protecting the business. They've gotten the citation dismissed, so they're saying basically there was no curfew violation. He had the right to be there. And then they'll work on the gun in terms of him being able to defend himself regardless of what his age was. So the defense at this point isn't necessarily building a case because they're not obligated to do that. They're undermining the government's case, and frankly, it appears that they're doing an effective job.
Patrick Cafferty, defense attorney and legal analyst. Patrick, thanks so much again for your time this morning, and we'll see you again tomorrow. Our Stephanie Haynes is in the courthouse every day and will bring us the latest on TMJ4 News at 5 o'clock this evening.
Top